loopholes. And it is in knowing the loopholes of the law that some lawyers will hang on, especially defense lawyers, to ensure that they carry through to a large extent and to a very long time frame the issue of a judicial adjudication. And a matter will hang on in court for donkey years. Either it is started pro bono, which is also a major challenge. Once a judge or a magistrate is moved out of handling that particular case, even if the case is nearing the point of delivery of judgment and another judge or magistrate comes in, he starts afresh. And I mean, there was this particular case of the late Chief Bola Ige, where 4 judges handled the matter before there was what could be seen to be a dispensation. And each judge that handles the matter starts it afresh. So part of the thing that this new act tends to curb is this issue of pro bono. And what causes that? If there is inadequate electronic recording system, then the new judge that handles the matter will not know where the former judge stopped and what had
So he has
transpired.
to start all over again with the evidence and the
so
argument.
The lack or depth of infrastructure is also part of the problems and part of the challenges that we have in dispensation of justice. Because he is not going to rely on what is not properly recorded to continue the matter to its logical conclusion. So he has to start all over again. So in an environment where there is such problem, an environment where even the other basic infrastructure of convenient and conducive courtroom is lacking, I have seen cases in the north where justice was dispensed under a tree. Why? Because they didn't have a conducive courtroom. The courtroom was blown off by a whirlwind, and then it was not quickly fixed. And the body had to dispense justice. Crimes are committed on a daily basis, and then fresh cases come to court. Even the old ones need to be dispensed, and in all of that, it now led the man on the bench to come under the mango tree in the morning, dispense justice, and left before sun would eat. At the end of the day,
and such justice stands.
Why wouldn't it stand? It was dispensed by a court of competent
jurisdiction.
Even though it's under
irrespective of the location. Irrespective of the location. Because justice is not only to be discharged in the courtroom. There are, in some cases, what we call visiting the scene, right? If a judge moves to the scene of action to see what is there, even if he made pronouncements in that place, it becomes part and parcel of the judgment.
Okay. Let's Mr. Bahab, let's get back to you here. Now, still looking at that law, the law is supposed to limit the time spent for the remand of suspects in custody. We limit it to a maximum of 14 days before a review of such a case by a magistrate. Now, or 14 days without arraignment, so to speak. Now, would this in any way affect the already existing?
Of course. When you are talking of access to justice in broad terms, you are not just talking of access to lawyers or access to litigation. You are talking of all other things that will make the attainment of justice easy and realizable. It encompasses what you have said. The law must be concerned about not just detention, but the length of detention. The law must be concerned about not just punishment, but the appropriateness and severity of punishment, commensurate with the offenses committed.
If I may come in there now.
Yes.
I asked that question so that I can tie in the 4 components he mentioned of the entire judicial system.
Yes.
The police, the
lawyers,
lawyers,
the
the
judges.
bench,
Yes.
and the prison officials.
Yes.
When you talk about dispensation of justice or access to justice here, you said there has to also be taken into consideration the issue of remand or detention.
Yes.
The welfare of that individual that's being detained, as the
Yes.
case may be.
Yes.
How has it been? It's not been good, so to speak.
Yes.
So how would this work, and when would it begin to take effect?
Yeah, it will begin to take effect if litigants who access the court are fairly treated. The test is fair treatment. Fair treatment, equal treatment, treatment in conformity with constitutional provisions. You understand what I'm saying? A situation where somebody is accused of an offense is detained for longer than necessary. That's an infraction to his right to justice. We shouldn't celebrate that. For instance, when the big man is caught for having infringed upon the law and is detained for weeks, for months, without being taken to court, you are also infringing upon his rights. That is why the basic components of access to justice is so wide. They're so wide. When you talk of access of justice, you are not only talking of normative legal protection. You are also talking of legal awareness. You are talking of access to legal aid and counsel. You are talking of effective enforcement remedies. Mm-hmm. You are also talking of effective adjudication, processes. And you are also talking of effective, and efficient administration of justice. Whereas of all concerned in the administration of justice are respected.
Let's get to the legal awareness.
Okay.
Part. This law has been passed. This president has signed, the former president has signed it into law. How many litigants, and indeed, how many people are aware of this, and how many of them are beginning to use it?
That is precisely the problem. There is lack of access to justice where there is no legal awareness. That is why you must call on all the stakeholders in the administration of justice to guarantee this.
So the stakeholders here being the police, the lawyers, the bank,
the police, the lawyers,
and the citizens.
And the citizens.
You know what? I think we should explore these 4 components. Let's start with the police. There's someone who's been arrested, and then the person is locked behind the counter for how many days without maybe proceeding to court or seeing if it's an issue that can be settled at the police station level. Is there any issue that should be settled at the police station level?
For instance, yes, the police are law enforcement agents. There are a lot of cases that the police try to criminalize that ought not to be the business of the police. For instance, somebody is owing debt, and then you go to the police. They are not supposed to be the debt recovery agents. Or somebody has infringed against the law, and the police just detain the person for days without allowing the person access to lawyers, without taking the person to court. That's an infringement against this access of justice to justice that we're talking about. You see, we are talking of a civilized method of adjudication that will have respect for all, both the accused, the suspects, the party who is complaining. For instance, you take a case to the police, and before you know it, you are turned to the accused person. The complainant is suddenly turned to be the accused person. Or you go to the police, and you want to ask for the right to bail suspects, and they ask you to bring so amount. All of these infractions that we treat as if they are normal, they actually impact on what? Access to justice.
Now,
so broadly, simply put, when you have access to justice, when all are treated fairly.
I want us to look at each, as it stands. We are looking at the police now. You've mentioned some of this. How do we take care of such issues so justice is not delayed or denied at that level?
I think in all fairness to the Nigerian police, there is a lot of reform in their system. Yes, there are still some bad eggs, but there is a huge reform that has happened with the police system. And such reforms can only be sustained by the attitude of the man at the helm, that is the Inspector General of Police, who will now hand down instructions to the AIGs, the zones, first to the DIGs at the departments, to the AIGs at the zones, and the commissioners at the states.